Impact of Influence.
Covering true crime throughout the Southeast.
My ruling is this. On the law, the defendant has the burden of proving both the fact of the improper comment or question by the clerk of court, Rebecca Hill, to a juror or jurors, and two, prejudice suffered by the defendant, specifically that the Hill improper comments to the juror or jurors influenced the juror to vote to convict defendant Murdaugh. The facts. Did clerk of court Hill make comments to any juror which expressed her opinion of what the verdict would be? Ms. Hill denies A, and so the question becomes, was her denial credible? I find that the clerk of court is not completely credible as a witness. Ms. Hill was attracted by the siren call of celebrity. She wanted to write a book about the trial and expressed that as early as November 2022, long before the trial began. She denies that this is so, but I find that she stated to the clerk of court, Rhonda McElveen, and others, her desire for a guilty verdict because it would sell books. She made comments about Murdaugh's demeanor as he testified, and she made some of those comments before he testified to at least one and maybe more jurors. Did clerk of court Hill's comments have any impact on the verdict of the jury? I find that the answer to this question is no. Each member of this jury took their involuntary assignment very seriously. They obeyed the instructions of the court. They obeyed their oath. These good and decent citizens of Colleton County stood to their duty and rendered their verdict without fear or favor. It was a difficult task. 11 of the jurors very unconditionally said they either heard no comment, or if they heard a comment, it had no effect. One juror was ambivalent in her testimony. The clerk of court allowed public attention of the moment to overcome her duty. I have read the entire transcript of this lengthy trial, not an easy task. I have studied in detail all of the authorities cited. I have independently researched the case law, learned treatises, and scholarly articles on the subject. Although there is certainly a split in the federal circuits and in the states on the standard of review, I simply do not believe that the authority of our South Carolina Supreme Court requires a new trial in a very lengthy trial such as this on the strength of some fleeting and foolish comments by a publicity-influenced clerk of court. This is a matter within the discretion of the trial judge, and I am the trial judge at this moment. I do not feel that I abuse my discretion when I find the defendant's motion for a new trial on the factual record before me must be denied, and it is so ordered.
That is the voice of Justice told during the jury tampering hearing, which leads us to more Murdaugh stuff to talk about today. Hello, friend. I am Matt Harris, and she is Seton Tucker. And how do they join in the conversation?
You can find us on Facebook at Impact of Influence and also on our YouTube channel.
And we get to the YouTube channel. Please hit subscribe. That's super helpful to us, part of the Evergreen Podcast Company, and support our sponsors. He is back. We call him the professor from the University of Penn Law School and also a professor at Temple Law School. Matt Siembieda happens to be the father of Seton Tucker. Welcome back, Professor.
Welcome back. Welcome back.
Yes, let's go to it because it's getting close.
Well, I wanted to talk about, we've got this the oral arguments in Alec Murdaugh's appeal on his murder charges that scheduled, I believe, for February 10th at 9:30 a.m. Again, oral arguments in front of the South Carolina Supreme Court. I think we mentioned in our previous episode that you can tune in and watch those arguments with a link to the South Carolina Educational Television Network. I thought that I was just going to do that because I was I can watch it from the comfort of my own home, but I now have filed a media request to attend this hearing. I've seen the stamp, so it's there. I don't know, there's no order yet about who will be able to attend, but I did this based on my dad's advice because you said, what's different about attending a hearing in person?
Well, you get a sense of the room. You get a better sense of the judges or justices, how they're reacting to arguments. You get a sense as to the lawyers, as to what they feel is good, bad, or indifferent as to what's going on in a room. And generally, after an argument, I have a fairly good sense as to which way it's going to go. And I think
you have
that being
background
there,
in
you're going to
this.
get that sense. Pardon?
What's the background that you have in dealing with appeals and that sort of thing?
Well, in addition to going to, I think you said University of Pennsylvania Law School I went to, I clerked for a federal circuit court judge for a while, and I've argued over 30 cases to appellate courts around the country.
So you think you can definitely catch more if you're in person and in the courtroom?
Yeah, I would say virtually almost every single time I argued, I would say that at least 70-80% of the time I could tell you which way the case was going to go after the argument.
I watched Russell Lafitte. He was the Alec's banker buddy who was sentenced in federal court. He filed an appeal because there was this kind of last minute juror shakeup. He did end up get it remanded back to the court to try it again. And I could definitely tell while watching this that by the questions these justices were asking, which kind of way it was leaning.
I think that's a good way to look at it. Usually the questions from the judges tip where they're leaning and the way it's going to come out. And you can also get a sense as to how the lawyers react to that and how good or bad they sound when they make their arguments. But it's generally the questions and reaction of the judges going to give you the clearest view as to which way the case is going to come out.
And you have to be able to kind of flow with it, right? Because while you're doing these oral arguments, it's not like you haven't a lot of time. You just talk for a period of time. The judges kind of break in and they ask you questions along the way.
Yeah, and generally, you get, let's say 30 minutes. You can get a lot longer and get a lot shorter, but let's assume it's 30 minutes. What'll happen is that you ask for, if you're the appellant, you would ask for, 25 minutes or so and say 5 minutes for rebuttal. And therefore the other side, the appellees will have 30 minutes. And what'll happen very often is you get what they call a hot bench, which means the judges are well prepared. And the judges will then start to ask you questions fairly quickly. So even though you may have 25 or 30 minutes to make your argument, a good 60, 70, 80% or more could be taken up from questions from the judge and the way you answer them, which means that when you get these questions and you get the sense as to what the issues are the judges are faced with, you have to be able to answer clearly and precisely what they're asking you. You have to try to direct them to what you think is your best arguments, but at the same time, make sure you address their concerns.
Well, let me ask you that. Okay, so if they interrupt you, it's 30 minutes period. You don't get time tacked on. So you could speak for 2 minutes and the rest of time could be just answering questions.
Yeah, and sometimes what the chief judge will do, the judges in control of the other judges on the panel, and I know this is going to be the whole Supreme Court in South Carolina, what they'll do is the judge will say, I'm going to extend the period to argue by another 5 minutes, or you have time to answer the question and blah, blah, blah. So what happens is when you're up there arguing, there's a series of lights that come on. There's a green light when you start making your argument. There's an amber light that comes on that gives you notice you only have a few minutes to go, and a red light when you're supposed to stop. And so so the judge sees that also, and the judge may say, I'm going to give you a little more time to make your argument.
Has there ever been a time that you thought, okay, I'm going in front of this appellate court, and I think this is my best the best chance, and you get up there and then the judges start asking you different questions than what you thought, and you're like, all right, wait a second, they're really focused in on this issue. I have to maybe go in that direction.
I've never really, quite frankly, experienced it that way. What I've experienced is I thought I had 2 or 3 good arguments, and when I get up there, it's pretty clear to me the judges really think only one is a really good argument. So you need to then focus your attention on that one.
And like, how was so then you do your 30 and then the other person does their 30 and rebuttal or whatever. And then they take a break and we're done. That's it.
The judges will say, we take it under advisement. It's very seldom. I've been there a couple times where there's an emergency matter up in the appellate courts. I can think of a couple times around the country. And the judges will say, we're going to take a 10-minute break. Lawyers stay seated. We'll come back and make our ruling. But that's very, very rare. I've seen that maybe in less than 1% of the cases that you see out there. And I've only had it a few times myself. Generally what happens is that the court says we'll take it under advisement, and then sometime thereafter an order or an opinion will be written.
So how long do we think usually is that? Within 30 days, or it could be longer?
It could be shorter too. I mean, for example, the federal court in New York, the Second Circuit, is notorious where if they feel an opinion is not very good and they're having oral argument, they'll make that pretty clear. And then what they'll do is they'll issue an opinion or an order that afternoon or later that day, and maybe even assess attorney's fees against a losing side. Mm-hmm. So I've seen that happen in New York a couple of times, not to my detriment, but I've seen it happen up there.
I definitely think in the evidentiary hearing that in front of Justice Toll to determine this tampering stuff, she came back very, very quickly with her decision. So it seems like maybe she had an idea of which way she was leaning going into it. In your experience, do you think judges usually have a leaning when they're going into it?
Yeah, you got to understand the process, and I learned that from my clerking days. What happens is the judges generally have a leaning when they go in. They're trying to bolster it or get more information in support of it. And then immediately after all the arguments for that day, the judges usually have lunch together. And during that time, they make a preliminary decision as to which way they're going to go and assign the opinion to one of the judges to write. And then it could take, then they circulate that opinion for review and comment. And if people agree, they sign on. If they want to have some suggestions, they give those. If they don't agree, they can write a dissent. If they agree, but not completely, they'll write a concurring opinion. And that'll take a little time to get together. So to answer your original question, generally it takes at least 30 days, sometimes, a good 6, 7, 8 months for an opinion to come out.
Wow.
I've been involved in cases where it took a year for the opinion to come out.
Jeez.
Well, and we should note that Alec Murdaugh is no real rush. I mean, he is serving 27 years for his state court sentence for his financial crimes, and I believe 40 years for his federal court sentence for financial crimes. So he's not going anywhere, and it doesn't seem like he's getting out.
Even set the argument for this case took almost a year.
Yeah.
Right.
Yeah. Well, so let's talk about, there was a motion to request a supplement of the record by the appellate, Alec Murdaugh, and they sought to introduce exhibits about Becky Hill. One, Hill's indictment for perjury. Secondly, Hill's perjury sentencing sheet. And the third thing they sought to introduce was the transcript of Hill's guilty plea, which that was December 8th of 2025. And that motion has been granted. There's an order allowing the record to be supplemented. What does this mean?
It means to question the credibility of Becky Hill at the time that Judge Toll held the argument. I know Justice Toll at the time of the argument said that they didn't find Becky Hill to be, I think, completely credible, completely being the key word there. So it made it sound like there was something she found her credible on. And obviously there was a great deal of testimony by jurors about what was going on with Becky Hill in the proceeding. And I know there was a lot of controversy about what jurors were saying and how that was received by the judge. And what they're really saying is that because of the testimony, there should be no doubt that Becky Hill shouldn't be given any credibility with regard to her testimony.
Now we should note that she was never charged with tampering, and during this hearing where she pled guilty to the perjury and some other charges, I think perjury being the most, I think you have a list of them, the most serious of the charges. The judge at that hearing said, my sentence would be different had there been evidence found of tampering. So he's saying tampering, and there's questions about whether SLED was the right agency to conduct this investigation, questions about whether there was an effort to preserve the verdict, but nonetheless, she was never charged with jury tampering.
Well, but the 2 points I'd make as to that. The first point is that she pled guilty to perjury, and that basically was allowing the press to come in and review sealed materials of the court proceeding that was going on, and that material ultimately found its way into social media and to the public in various ways. At the time of Judge Toll's hearing, Justice Toll asked her if she allowed the media to review the materials, and she said no. So that on that basis, they're saying that how can you believe anything that Becky Hill said during those hearings, and that means that her testimony is all impeachable or not credible, and all the testimony of what the appellants called the disinterested jurors ought to be considered over Becky Hill's testimony. Of course, we don't know what Judge Toll, if anything, relied upon from Becky Hill. The only thing we have that she said is she didn't find her to be, quote, completely credible. So I think that one way to read this is that there's 2 ways to read it. One is that it allows the appellants to argue that somehow that Becky Hill's testimony at Judge Toll's hearing influenced Judge Toll's decision, and that as a result of that, it gives the justices in the Supreme Court a way to basically reverse what Judge Toll did without criticizing Judge Toll, because Becky Hill basically lied to her when she testified, and that's what she was pled guilty to in the proceedings that took place. So bottom line is that I think that it gives another way for the defense to argue, for the appellants to argue, and it gives the Supreme Court a way out of the case without being critical of Judge Toll.
So it doesn't matter that it's not specifically jury tampering that she pled to. It's just overall that she has this felony charge for jury tampering or for
Perjury.
It goes to her credibility about anything she might have said at that hearing.
Right. So why can we trust what she says versus what some of the other witnesses who have testified in affidavits that were submitted that maybe were contrary to what she said?
Particularly the jurors, absolutely.
Well, however, there's the question, though. If the prosecution is admitting that she said stuff, although they say foolish and fleeting comments. So they admit that she said something. So whether or not Becky's credible or not, one would argue it doesn't matter because she said something. The prosecution admits she said something. The defense says she said something. But the question is, how did that affect the jury and whether we're using Green or Remmer or what we're relying on?
Yeah, the problem the prosecution has in this case on this issue is that the person in the center of the jury tampering is Becky Hill. And the Judge Toll rendered a decision saying there was no jury tampering. And yet now we have Becky Hill pleading guilty to perjury, namely that she lied to Judge Toll. So the question is, did she lie about everything? She was central to the case, and therefore she's impeachable. Therefore, you believe the disinterested jurors, as Seton said, and the case ought to be sent back for a new trial.
Well, I want to talk about this is a little different. I was just thinking we've had a couple of posts this week, and I went back and listened to some of the testimony during the evidentiary hearing in front of Justice Toll, and a few things kind of came to mind. One, we never heard from Bailiff Bill. He was the bailiff who was in charge of the Murdaugh jurors. He was there every day. Arguably, he is the person who would have had the most contact with the jurors. I was thinking about this. I was very surprised that he was not called for the evidentiary hearing because it seems like he could confirm or refute some of the claims that were made. So I found that really interesting. And we don't know if he was interviewed by SLED during the course of investigation. Now, at the hearing that Becky Hill pled guilty, she said that, the judge said there was no evidence of tampering, but we still don't know. We don't have all of the information that went into that investigation. So I am interested to know if Bailiff Bill was interviewed. The other person I found kind of interesting, and I went back and watched her testimony, was Rhonda McElveen. She was the Barnwell, I think still is the Barnwell County Clerk of Court, and she came to assist Becky Hill during the Murdaugh trial because it was such a big production and she needed extra help. So Rhonda testifies during this evidentiary hearing that she never heard Hill make any sort of comments to jurors, but what she did hear was Hill make similar comments to what was said by some people, like watch him closely,
Watch his body language,
pay attention. So she heard some of these comments which were similar to what some of the other jurors said that they heard. She also says that
which, by the way, is very important because it collaborates what the jurors said.
Right.
That's what's her state of mind.
Exactly. She also says that she came to her attention that Becky Hill had driven a juror home. And when she learned about this, she said, please, she approached Becky Hill and said, please tell me you didn't take a juror home. And she said, well, I did take a juror home, but we didn't discuss the case, and Bailiff Bill was with us. So that also brings up this Bill case. So anyway, I think that, we've got the testimony in this evidentiary hearing of Rhonda McElveen. And also we never heard from the egg juror.
Yes, the egg jury was not called because she was dismissed a couple hours before they went in for their final arguments.
Right. And they said because she was not a sitting juror, they didn't call her. We did hear from the alternate juror who kind of maybe also said that she heard some things, Becky Hill say some things. There was that testimony from Mandy Pierce, who was kind of the crux, I think, of the evidentiary hearing, because she was the one who said that she was influenced by Clerk Hill. And then when she was questioned again by Justice Toll, says, I also felt pressure during deliberations, and pressure during deliberations is kind of a normal thing. So, it was just, to me, it was a little bit ambiguous. Was maybe she was both. Maybe she felt influenced and pressured.
And it was ambiguous, and also to the point that Joe McCullough, who was sick, just recovering from his heart problems, wasn't there when she did her testimony, but he sent Toll messages that Mandy would like to clarify, and Toll said, no, I don't want her to clarify what she said.
No, and, so, but that, I guess the question is, maybe she didn't find Pierce entirely credible, but maybe, I don't know, how do you weigh the credibility of Pierce versus the credibility of Hill?
Yeah, and I think that's what they're trying to get into with this credibility testimony here. I mean, the jury is supposed to be an independent third party. She's not been charged with any sort of misconduct on her part as a juror. She's saying what she saw, what she did, and you have Becky Hill, who's pled guilty to perjury on something directly related to the case. And so, you look at it that way, and it seems like you ought to be believing the juror over Becky Hill is what the defense, is going to try to argue here. And that's pretty clear. To get to your other point, it seems to me that if there are other witnesses out there like the bailiff, they should have been into the case unless there's some good reason for it, which we don't know about. But
he might have been interviewed by SLED, but he was not interviewed by Justice Toll.
I mean, don't you think, or why wouldn't the appellant, why wouldn't Alec Murdaugh's team call Bailiff Bill?
I don't know, unless they felt he wasn't going to be helpful. But, you would think they would call him anyways.
Yeah.
They can call. Could they call him at the
I think
hearing?
they could. They called Rhonda McElveen. I think they got the permission to call Rhonda McElveen.
They could call her. They could.
Yeah.
Just kind of food for thought. I don't know. It just got a lot of people are still really interested in this. A lot of people are like, oh, you're in the Murdaugh camp. And no, we're not in the Murdaugh camp. We're in the, let's present all the information camp.
Mm-hmm. Yeah. And I think it's important in presenting the information to understand that this is really not about the guilt or innocence of one party. It's about making sure our system of justice is upheld, that as Matt Harris says, justice is blind.
Right.
And that everybody gets a fair chance. And that's what that's about. If the evidence is clear and strong, Alec will be convicted a second time. There may be a different trial, but based upon the evidence that came out at the first trial, particularly that video that Paul took that he lied initially to SLED about, seems to be pretty damning to him. The defense on the other side, I'm sure, are going to have a completely different case. So they're probably going to try to get Alec off the stand, or will keep him off the stand. They're going to work like crazy to keep out any of the financial information that's out there. They're going to try to point out all the missteps that SLED and the state made in its investigation, such as not shutting off the house, about not exploring the tire tracks, about all the digital evidence that was out there around there, about not having a weapon, about not searching for other potential suspects. They're going to go after every single thing they can to try to create a doubt in the juror's mind. With that said, the strongest thing they have to overcome is that very powerful video that Paul took of Alex there shortly before he and his mother were killed. This is not a case as supporting Murdaugh or not. It's just simply an analysis as to, did he get a fair trial? And then if he didn't, there's a new trial, what the trial should look like.
All right, 2 questions. One, what do you think the chances are at this level? Obviously, if it's not at this level, I would assume they would appeal another level. So what do you think the chances are? And then if by chance he does, what do you think that they will retry, or there may be some sort of plea deal?
I think that there's a decent chance that the court's going to send it back for a new trial. I know the chief judge wrote the Green opinion, which is the opinion in Pennsylvania the state relies upon because it found in one particular case the statements of a bailiff were procedural and didn't affect the outcome. Now, in this case, you have pretty direct testimony about Becky Hill, who now is a convicted perjurer, about her conduct, her expressions to juries, her, quote, allegedly tampering with jurors. That's going to be pretty powerful evidence going back to the federal Remmer standard there. And I think the Chief Justice, who wants to open up a new era of courts in South Carolina, develop more trust in the court system, more transparency, I think they're going to give Alex a new trial, and Alex is going to have to go back and face justice again. Now, will there be a plea deal? Sounds to me like it's going to be pretty difficult to come up with a plea deal that works. I understand that he is to quote an old movie, he's on a mission from God, the Blues Brothers. Yeah. He's on a mission from God, and his mission is he doesn't want to be convicted of the death of his wife and his son. I mean, shortly before his son's death, I know there was a video of him out in the meadow with his son, fooling around with a willow tree or something, and very friendly and stuff like that. There didn't seem to be any evidence that I've seen that's come out about he and his wife being in bad way with one another. So he's going to try to clear his name, I think, is what he's going to try to do. Whether or not he can, it's going to be tough because of that video that's out there that Paul made. So we'll see what happens. There's a lot for the defendants to work with, and that's the first step. Get this case reversed, get a new trial, and to work it like crazy, and don't make the same mistakes you made the first time through.
Because I want to touch on Remmer just because we mentioned it a couple of times. Just explain Remmer, what that
Remmer's
means.
the federal standard.
The federal standard says that there's a presumption if there's any contact with a juror by a court member that's prejudicial and there ought to be a new trial.
It doesn't matter if the juror said that didn't have an effect as long as they said it.
Yeah,
it
because you can't go out and, you can't take the wine out of the glass once you pour it in.
Yeah, yeah.
Well, and the Green case, actually, interestingly, is the South Carolina Chief Justice Kittredge. That is his case. But I think that it's not saying that necessarily is a wrong case. It could just be that it's different. I think this involved a bailiff with some more procedural type things.
Right.
So he wouldn't be going against his ruling by doing that. Yeah.
He'd be making a distinction. He'd be saying what it means and the standards being filed in South Carolina. Which basically is if there's any contact of any nature with a jury about the case itself, that's going to be considered jury tampering, and the case ought to be set aside and new trial ought to happen.
So these justices, when they're ruling, they are also thinking, okay, this is setting precedent. It is setting case law going forward. That has to be in their head a little bit, right?
Right.
Okay. So, so they get.
The other thing is, Justice Toll is highly regarded former Chief Justice of the Supreme Court, and she got this the first time through and ruled. And that's why I think it was important that they filed this motion to supplement the record and question the credibility of Becky Hall, who was central to the whole suggestion it was jury tampering.
So, because then you're like you're saying, this is new information. What this guilty plea just happened in December of this year, or last year, actually, we're 2026 now, but just happened just a short while ago, a month ago. So they can say, well, Hill didn't, or Justice Toll did not necessarily get it wrong because she didn't have that information at the time that she ruled.
Yeah.
That she, she only said that she didn't find Becky Hill to be completely credible. She shouldn't be credible at all, is what they would argue.
Gotcha.
And we don't know what she meant by completely, but it gives you the ability to say that Justice Toll, unfortunately, was lied to, and therefore we have to look at it afresh, anew.
But in the same respect, the state is going to argue, hey, look, when Toll rendered her decision, she said she didn't necessarily find Becky Hill credible. So she took that into consideration that that Hill in her mind was not entirely credible.
Well, she said completely credible, right?
So that's the needle there.
Completely. So it leaves the room that there was some credibility she relied upon.
Right.
And that was the error in her ways, is what someone would argue, I think, to the justices on the Supreme Court.
Well, it'll be interesting. Place your bets now.
And I think what the prosecution's probably going to counter with is that, Justice Toll spent a lot of time with the jurors and a lot of time in the case, and Becky Hall, she didn't get much credibility too. She even said it, as Seton said. Therefore, just rely upon what Justice Toll did, and she's the one in the first instance that had the factual review as to what took place here, and therefore uphold the appeal. That's what the state's going to argue.
There we go.
There we go.
The professor, thank you very much. Put it on your calendar. We'll all be
enjoy yourself. It'll be fun, and I'm sure I'll watch it or listen to it when it's going to be on TV, I guess, right?
Yep.
Yeah, South Carolina Educational TV.
Hopefully, we'll be there.
It should be interesting.
And always great to hear from your dad, the professor, Matt Siembieda. We always get a lot of great comments whenever he's on.
And we had to record it twice because we forgot to record.
I forgot.
So I think it was better the second time.
Let's hope so. That's what we'll tell ourselves. No one knows because no one will ever hear the first time.
I know.
But that's part of, if you join the YouTube channel, we are getting better. We're learning. We're a two-person operation here, folks.
And we're not the best with technology.
But we're getting there. We're getting there. With your help, the more subscribers we get, the more help we get in order to do some technical things that we need to do. So we appreciate it. We're always grateful about it. And we're grateful about even the Facebook comments, which may or may not be against us. That's fine too.
Well, no. Okay. So somebody put a bird in my ear that there was an order about this motion to supplement the record in the Murdaugh that we just talked about with my dad. And we posted it. We were the first people to post it.
Way to go, Steve.
So, I mean, again, I can't take full credit for it. But
I don't know, there's a lot of people out there, so-called journalists, who take credit even though it was somebody who told them to look.
I found the motion, and the order had actually gotten buried. There's some media requests. Those are actually all being filed in the public index as well, which I thought was weird. So, I could see our names up on the public index as well as everyone else who has filed to attend the oral arguments. But anyway, I think there was 125,000 views to date, 153 comments. So people are still actually really interested, I think, what is going to happen with this appeal. I thought this was a really great comment, which kind of mirrored a lot of what my dad had to say.
All right. I'll handle the comment. It's from Andrea. This order doesn't decide anything on the merits. It simply allows the appellate record to be supplemented. That matters procedurally, but it's not a finding of jury tampering, and it's not a ruling on a new trial. What it does do is let the defense argue that Becky Hill's credibility should be weighed differently given her perjury plea. That's an argument, not proof. The court will decide whether that's credibility issue is legally significant. This is a door being opened, not a conclusion being reached. That is very well said, and that's exactly
that's exactly what my dad said. I thought this was such a great comment, and there was a lot of discussion back and forth. It was very respectful. Not all the discussions on our page are respectful, but I thought this one was a really great one, so that's why if you want respectful discussion and you want to debate, even if people are disagreeing, I think it's a great place to do that.
Yeah, we're not the kind of people who are going to block if you say you don't like how we handled something.
No, I'm against. We can take it. I did block a few people at the beginning, and actually I went back on our page and figured out how to unblock people. I was like, I don't care anymore. Come on our page and say what you want.
It is what it is. Keith commented, Judge Toll ruled that even if Hill did tell jurors to watch Murdaugh's actions and body language on the stand, the defense failed to prove that such comments directly influenced their decision to find him guilty. This was confirmed by the investigation by SLED and 11th Circuit Solicitor Rick Hubbard's investigative team. Taylor said Hill's sentence would be much different had Hubbard's team uncovered any sort of tampering with the jury, the most sacred part of the criminal justice system. That is true. I don't think anybody's arguing that, which both these comments said, that there was confirmation of jury tampering that does possibly change. Your dad kept going to the one sentence, which was, Justice Toll said something like, she's not completely credible. Like there's like a little word in there that allowed, instead of not being at all credible.
I wish we could bring my dad back on, because another thought I had in regards to Keith's comment was, maybe it didn't rise to a level that she could be criminally prosecuted for it. But does that mean that jury tampering didn't happen?
That's very true.
I wish I could have brought that up with my dad. Sorry, Dad. And we'll
right.
talk about it on another day. We also had some questions about Becky Hill's son on our page, because I did look it up. He still has pending charges in Colleton County. He was working for the courthouse at the time, I believe, in like an AV type capacity. And there's some wiretapping charges that are still pending out there. So we don't know what's happening with him, other than that those charges are still pending.
Right.
Also, Wendell, he said that, asked him, he had asked him, like, are you suggesting that we're on Murdaugh team? He said, there's no suggesting. All of your content is pro AM. Hence why I stopped listening to your podcast. He will never be free. And that's DOC fact. I don't know what that means.
Department of Corrections?
That's DOC fact, no matter how you spin it. Anyway, he goes on. Anyway, we're sorry to lose you, Wendell, as a listener, so maybe you're not going to hear this, but I don't think we're pro Murdaugh. We're pro information and pro facts. I mean, we're going to report everything, and we really are not trying to take a side.
As far as the justice system goes, it doesn't matter if Alec Murdaugh is a scumbag or not. As far as
there was a lot of comments about he's the worst, he's guilty, but why are we wasting taxpayers' money on this kind of stuff? And I'm like, whoa, all these things are true, that he definitely seems not to be a good person. But I would say that this has less to do, someone's like, Alec Murdaugh has no credibility. I'm like, it has less to do with Alec Murdaugh's credibility. This has nothing to do with the facts of the case. It's just about whether he got a fair trial.
It has nothing to do with whether guilty or innocent. It's about a fair trial, which is important to even the guiltiest of the guilty.
And a ton of questions about how the defense team is being paid. And I did reach out to Dick Harpreetland, and he declined to comment about that. So we don't know.
Could be friends of Murdaugh, relatives of Murdaugh. It could be a big contingency they got at the beginning and they still have money left. It could be because they're friends.
Lawyers are not allowed to take money from ill-gotten means, but not saying that criminals don't find ways around that. I have no idea. But again, we don't know. But a fair question. It
is a fair question. And in the long scheme of things, it doesn't really matter to the point of whether this was a fair trial or not, how Harpootlian and Griffin are going to get paid.
I think that people are looking at the people who were scammed out of lots of money, and how is he paying for, these high priced lawyers when, other people are dealing with, public defenders.
Again, true. But a side issue really compared to a fair issue compared to was it a fair trial or not? Like the Supreme Court's not going to weigh in on who paid Harpootlian and Griffin. That's not part of it.
Yeah.
It's part of it is, was it fair or not?
Right.
I guess we'll see what the Supreme Court says in just a short period of time. And then, boy, will the opinions come flying out.
They will, I'm sure. Well, we will hear those oral arguments, but then like what my dad said, it could be some time before we get an opinion from the Supreme Court.
I was really surprised that it could be a year, another year of waiting. Could you imagine?
I don't know. I mean, I don't know if he is thinking of that, because he deals more with the federal court system, I believe, than the, South Carolina Supreme Court system. So maybe, as this is like in the news, maybe they'll
speed along.
I mean, Toll rendered her verdict that Seconds.
Just took a lunch break.
Yeah, she took a lunch break, and she had a whole order written.
Right. Always grateful, my friends. Facebook, Impact of Influence, YouTube, Impact of Influence. Hit the subscribe button. As I said, we're grateful, and we'll talk soon, friend.